Moving on, Supreme Court has dismissed petitions seeking review of the Constitution Bench judgment which allowed sub-classification of the scheduled caste. Now, the Supreme Court, it has rejected the August 1st judgment which upheld the power of states to sub-classify reserved category groups vis-a-vis the scheduled caste and the scheduled tribes into different groups based on their backwardness for extending the benefits of reservation. And my colleague Sunil Prabhu joins us to get us more on this story. Sunil, two parts to my question. What are the key points of this judgment, and what does this judgment mean in the larger context and future calls for sub-classification within scheduled castes?
Well, as you pointed it out, first, of course, there was a review petition against this sub-classification order that has now been rejected by the Supreme Court. What was that judgment that came about? That was a 6:1. One dissenting judge, Justice Bela Trivedi. There were 6 from the Chief Justice, Justice Mishra and others, Justice Gawai, host another 6 of them, all agreed that there should be sub-classification of the scheduled caste, scheduled tribes. What does that mean? That within the scheduled caste, that there could be further sub-classification, but it has to be based on empirical data on certain parameters that can withstand and show scrutiny in terms of that there has been backwardness of that a particular community, and that is why they're doing it. Which are the states that were demanding it? States like Punjab, Andhra Pradesh, for example. They are the ones who have been seeking and wanting some kind of sub-classification so as to ensure that the scheduled caste, the poorest among the scheduled caste and the scheduled tribes would be able to get that benefit. And it's in that context that the Supreme Court, 6:1, have agreed and said yes. There was already a cabinet rejection on the, what was clearly not a direction, but a reflection in terms of a majority of the judges who said that the creamy layer should be applicable for even scheduled castes. But that was rejected by the cabinet, which has already been put out. But today's decision of the Supreme Court to reject it means that now it is here to stay, sub-classification of the scheduled caste, scheduled tribes, and that does not stop or deter any particular state or center in ensuring that those who want the benefits of reservation amongst the poorest of the poor, be it in scheduled castes or scheduled tribes, they will be able to get it because there is a Supreme Court order which permits it to do so.
All right.